Good morning, ladies and gentlemen. It's 9 o'clock. My name is Dave Beattie. I'm the Legislative Compliance Manager at HR Talk. Today, we're going to do a webinar on COID and IOD claims. Just to give you the heads up, I have had some challenges with a couple of the slides when I share it. I've tested it, internally here, and I've done with other clients, but it seems that when I share it on this profile, it doesn't pull up certain of the screens, of the slides. So what I've done, I'm just going to leave the presentation in this format and we will proceed. I have done this webinar before, but I have added to it. So if you have been on the webinar before, please be patient. I will go through some of the new issues. Okay, so COID, we know it as workman's compensation, but COID stands for Compensation for Occupational Injuries and Diseases. Workman's compensation is, maybe up front, let's say that a surprising number of companies are not registered for workman's compensation. A lot of people don't understand it, and a lot of people do not understand that it's compulsory. So we do a lot of registrations, and today the aim of the webinar is just to give you an idea of what it is, how it works, and the implications to the employer-employee, and what happens if there's injuries or deaths or illnesses. We're going to go through those issues. I'm going to go through it quite quickly, and you're obviously welcome. You will get the slideshow sent to you, so you will be able to go back to it and look at it. So yeah, just to repeat, COID / workman's compensation stands for Compensation for Occupational Injuries and Diseases. What is the purpose of COID? Okay, now a new business or any business, as soon as you employ your first employee, is required to register with COID within 7 days. Now, the law might say that, but we know that that doesn't happen. Generally, if you are registering and there's an issue, workman's comp will honor the claim. But rather than tempt fate, it's always a good idea, as soon as you've got that first employee, to do the registration process. Now, COID provides compensation to cover employees who get injured on duty, disabled, or die. It also covers any diseases that the person might have as a result of their work environment. Who cannot apply for COID? You cannot apply for COID if you do not have at least one employee who's not a director or shareholder of the company, or if you're a sole trader and do not have any employees working for you. Now, the first one is a little bit challenging for me because there are lots of companies that have a working director. So what this is those people aren't covered, so they would have to have some form of personal accident cover. What is a CF registration number? That term is bandied about quite a bit. The CF registration number is the number that you receive from COID once you do the registration process. And that CF registration / COID reference number starts with a 99 and at present has 000 after that, and then 7 unique numbers that will be obviously unique to you as a company. Do you have to register each company for COID, whether it's a branch of an existing company or new company? Yes, each branch must be registered, and each of those branches will have a separate registration number. And the logic behind that is a company may have lots of different companies under its holding company that do different things, that have different risk attached to it, or have different claim histories, because that also dictates payments. So in a nutshell, yes, you have to be registered separately. What form should be completed to register for COID? That form is called a WAS2 form. If you're registering as an employer of a domestic, there's a more recent form, that's a CF1E form. And unlike the WAS2 form, the COID registration form for companies, it requires the employee's personal details. Now, for a company registration, all you do is you're putting numbers of employees and you're putting in expected annual remuneration of those employees subject to the limits. And as long as that employee was in those numbers, they would be entitled to benefits. Should the application be done online? Yes, it is recommended that it be done online. I prefer to do it manually, and I utilize a company to do that. And the reason I do that is to ensure that the company or the organization being registered gets put into the right category. The right category is a problematic term because COID have lumped numerous things into categories, and often the description doesn't match what the employee is putting on a form, and that can create challenges and concerns. And as I said, I utilize a third party based in Johannesburg to do my registrations. Now, as you can see, the slide is not being displayed, but on the left-hand side, you'll see slide 5, what the actual COID registration form for companies looks like. And then the next form is the COID registration for domestics. Now, COID is not the only body that deals with workmen's compensation. Organizations may register with RAND Mutual Assurance, known as RMA, but only certain organizations can fall into that category. And those are companies that fall into class 4, which is mining, and class 8, which is iron, steel, metal, and related industries. So generally the process is registering with Workman's Comp first, and then doing a parallel registration with RMA and doing submissions via the RMA. The second body that we will deal with is Federated Employers Mutual Assurance Company, otherwise known as FEM. And this organization has a license to work in the compensation space in the construction industry. So generally, if I'm doing an audit, I will ask whether the organization is covered for one of those three organizations. How is the COID subclass and rate determined? It's based on the products and services that the company provides, and like I said, in terms of risk, obviously the subclasses each come with their own rate, and that rate is higher as the risk gets higher. So the rate will increase as the risk of injury in a particular industry increases. As an example, if you're an accountant and you're doing a very much administrative office-based job, that rate would be significantly lower than mining or demolitions or something like that, where the risk of injury or death is higher. At the end of each year of assessment, the COID liability would be determined by multiplying this rate, and it's normally a percentage of a percentage, so 0.025% or something like that. And that is multiplied by your COID earnings for the period to date. So what is included in COID earnings? I've bulleted them there. In a nutshell, we're looking at all regular earnings. So your salaries, your fixed allowances, your regular overtime, a guaranteed 13th check, housing allowance, commissions, meals and accommodation, anything that is in your contract would be included in your COID earnings. What is excluded from COID earnings? Reimbursed allowance subsistence, reimbursed travel, occasional overtime, ex gratia payments, occasional payments, company contributions to medical aid and retirement funds, and any non-recurring payments that fall outside your normal duties. So they don't want you to be inflating your COID contributions. The COID contribution is calculated on all your regular earnings. Now, the next slide is effectively the back side of your return of earnings. And this slide shows you inclusions and exclusions. And what I want to bring to your attention is fringe benefits. As you saw on the previous slide, company contributions to pension and provident and medical are not included in COID earnings. Other fringe benefits are. So the cash value of fringe benefits are. It's important to remember that. Is there an annual COID earnings threshold per person? Yes, there is. And this is published every year, normally in February, and it is applicable from 1 March of that year. So for the current year, the 2023 year of assessment for COID purposes, the threshold is 563,520. Last year it was 529,264. This means that if an employee is earning R1 million a year, only 563,520 can fall into your COID earnings. Now, if you're with a reputable payroll company or a payroll service provider, this figure is built into payroll, and your COID reports will limit automatically the person's COID remuneration. Now, if you're doing this manually, it's obviously quite complicated because you're going to have to go through each employee and determine whether the employee has earned over that threshold and then limited to that threshold. All reputable payroll systems will actually prepare a report for you that you can use for COID earnings purposes. Going back to the registration process, when you do the registration process, immediately after registration, you get a provisional return of earnings for COID purposes. This essentially works off your new COID rate and your declared COID earnings for the year. So up front, you've stated that you think that the COID earnings for your company are going to be 20 million. The provisional assessment is going to be based on your rates times 20 million, and you've got 30 days in which to pay that. Just a word of warning in terms of payments. When you make payment for COID, you must only ever use your 99000 number. If you don't, it goes into a suspense account and you will not get your letter of good standing. Don't put the company name or any other reference other than your 99000 number. Payment has to be made within 30 days. And as soon as payment is accepted and recognized by the Compensation Commissioner, you will get a letter of good standing valid for the next 12 months. Now, that is your provisional return of earnings. Now you get your annual return of earnings. Now, let's say you've registered as of 1 March 2023. You've paid your provisional assessment via your return of your provisional return of earnings. You now trade for a year, and at the end of February 2024, you've reached the end of your first year of assessment for COID purposes. You now have to return an annual return of earnings. We call it an ROE. It's on a WAS 8 form, and the legislation says that this has to be submitted by the 31st of March. But every single year that is increased to 31st of May. So by the 31st of May, you have to have made a submission. Most people do this online to populate your return of earnings and to create a provision for the new year. Now, you'll populate that return of earnings with the report out of payroll, and it separates we'll move on to now. It separates the employees' contributions and the directors' contributions. An assessment will be raised, and you've got 30 days to make payment, and similarly, you will get a letter of good standing. Slide 14 is just the front page of the return of earnings. Slide 15 is the one that I urge you to look at your own time. Slide 15 shows the months and the earnings for employees on the very left, and then in the column to the right, you'll see the earnings of directors. And then on the right-hand side of the page, you'll see the two fields for provisions for the next year, and that will be for employees on the left-hand column and directors on the right-hand column. Pretty simple. Is there a minimum assessment value? Yes, there is. So even if you submit a nil return, technically the Workmen's Compensation Commissioner will come back and say, our minimum payment is 1,443 Rand. Last year it was 1,342 Rand. And then for the registration of domestics for Workmen's Comp, that is now a requirement. That minimum fee is 498 Rand a year, and last year it was 463. Now, small price to pay for a domestic, in my opinion. If the domestic is injured on site or is ill because of something that's happened on your premises, you know that you're covered, and you know that there can be no civil claim against you as an employer. It is important to note that whilst you have a rate, that rate can be increased for your company in particular if you start having lots of claims. So it's important that you don't have risks in your company, slippery stairs, slippery floor, stairs that don't have a handrail, because if you have numerous claims, your rate is going to go up. Who needs a letter of good standing for COID? Everyone should have a letter of good standing. It's important to have, should the Department of Labour come around, pull out the letter of good standing to show that you're in good standing for the next 12 months. And very importantly, a letter of good standing is critical should you be in the business of tenders. If you're submitting tenders, generally, a tender requirement is a letter of good standing for COID and UIF purposes. Those of you who work in the UIF space will know that the electronic UIF letter of compliance process has been shut down because there's problems with it. So you would not supply a letter of good standing or certificate of compliance for UIF. You would just merely supply a copy of that letter to show that you are in compliance. Do you have to apply for a letter of good standing every year for COID? Yes, you do. That letter is only applicable for 12 months, in effect, that year of assessment. So you will apply for it annually. It's quite an easy process online, whilst as soon as you're in good standing. How does COID work? Essentially, it's the same as insurance, except in this case, it's a government instruction to register. So you might have some sort of employee cover through your private insurance. That doesn't trump COID, unfortunately. You're required to register, and this ensures that your employees are covered by government, in that the Compensation Commissioner to cover illnesses, injuries, particularly in factories where people may get injured on machines or whatever. Obviously, COID will cover those injuries and loss of income during the time that they need to recover. What does it cover, COID? It covers both the employee and the employer, no matter whose fault it is. Most importantly, and I stress this during my audits, the employee cannot sue the employer for an injury on the premises as soon as you registered for COID. Obviously, you know, if you as the employer are giving instructions to employees to take safety equipment away or take guards off dangerous machines, you're going to have a problem with the Workmen's Compensation Fund. But if you registered with Workmen's Compensation and your employee falls and breaks a leg, you have to lodge a Workmen's Compensation claim, and the costs will be covered by Workmen's Compensation. In terms of medical costs, all reasonable medical expenses will be paid for, including hospitalization, doctors, specialists, and medicine. The employee is free to choose a medical service provider they want to consult with. I've put in there, in practice, this is not always the case, because I am aware that in KZN, there's only certain hospitals that will take injured on duty cases. I know that those are Schlange and St. Augustine's at present. There may be others, but I know that our clients have had problems with other hospitals. And the reason that hospitals are not keen on IOD claims is the length of time that they wait for payment. The medical accounts should be submitted to the commissioner. The fees are paid according to a maximum tariff. Now, every single year, the Compensation Commissioner publishes a detailed tariff guide to show that what the workman's comp will cover in certain cases. And my last point I've said, it's important to note that there's no co-payments. Now, that may be one of the reasons why hospitals may not want to deal with someone, and also the tariffs. The hospital does not want to get into any sort of administration dispute with workman's compensation because of the length of time it takes, and they know that they're not going to get their money if there's been charges levied over COID tariffs. Now we're going to go on to the types of compensation. Temporary disability. Now, temporary disability is when the employee is unable to work, or they're only able to do limited work because of injury or disease, which can be treated, which with the employee ultimately returning to work. To claim, the employee will need to be booked off by a doctor for more than 3 days. So obviously that's a threshold to prevent unnecessary claims. If they're booked off work longer than 3 days, they'll get paid for the whole time they're able to work, including the first 3 days. If the employee cannot work at all, they'll be paid out 75% of their normal monthly or weekly wage tax-free. This is known as the days off or income replacement benefit. If the employee can only do some work, they may still get paid by their employer, but remember, they're still entitled to 75% of the difference between what they get paid and what they should have been paid by workman's comp. So in effect, they're going to get 75% of their normal wage or salary. An employee can claim compensation for temporary disability for 1 year. This can be extended after consultation with the commissioner and obviously the various doctors. And obviously, if the disability is going to stretch more than that, generally they're going to put the person on permanent disability. For the first 3 months of work, the employer pays the employee's compensation. This money can obviously be claimed back from the workman's compensation, normally at their own pace. So I know employers are not happy, but that is the law. After 3 months, compensation commissioner takes over the payments until the employee is fit to return to normal duty. For an occupational disease, the employee must pay the wage at the time of diagnosis and not the time when the employee acquired the disease. There may be quite a long difference in time there, and obviously the employee's rates of pay may have changed significantly. If the employee is now unemployed, the wage to be used would be what they earned if they were still employed. Permanent disability is an injury or illness that the employee will never recover from. In other words, losing an eye, a limb, something like that. It will obviously render the employee incapable of working again or incapable of working in that space. Disabilities rate from 100% to 1%, depending on their seriousness. So, for example, you lose your hands or your legs or your sight, you'd get 100% disability. If you lost the small toe or the tip of the small toe, you'd only get 1% disability. The employee's doctor would write a medical report about the disability, and then that would go to a panel and they would determine the seriousness of the disability. And the permanent How this disability is awarded for different injuries is set out in that schedule that I mentioned earlier. If the disability is more than a 30% disability, the employee will get paid a monthly pension. The size of the pension depends on what their earnings were and on the seriousness of the disability. If they have a 100% disability, though, they'll get 75% of their COID earnings, as we discussed in a previous slide. If the disability is less serious, the Commissioner will work out the monthly payments, and that will be paid for the rest of the employee's life. If the disability is less than a 30% disability, the employee will get paid a lump sum, and this is a once-off payment. Death benefits. If an employee is killed by an occupational injury or disease, the family can claim from the fund. And what I've done is I've listed there the claims that are able to be made in terms of a lump sum. The employee gets 2 months compensation, and then if there's a spouse, they get 40% of the employee's monthly wage, and there's a 20% monthly payments to the children up to the age of 18, and there's a once-off fringe benefit. Now, the legislation is quite broad, and children also include illegitimate adopted and stepchildren. If there's no spouse or children, then parents would get that benefit. In terms of additional benefits, if a worker is injured, dies, or contracts an occupational disease because of the negligence of the employer, the worker can get extra compensation for temporary or permanent disability. Any worker who's under 26-year-old at the time of this incident will get extra compensation. And this additional compensation is claimed on Form W930 and must be submitted within 24 months of injury. Now, once again, this is a tedious, time-consuming process, so don't hold your breath. An unexpected occurrence at a specific date or time arising out of and including the course of the employee's employment, resulting in a personal injury or death, or when an occupational disease is contracted due to exposure at the workplace. Now, that is your definition of injury on duty or an occupational disease. Let's go through it again. It's an unexpected occurrence at a specific date, time, and place, and arising out of and in the course of the employee's employment, resulting in personal injury or death, or when an occupational disease is contracted due to exposure at the workplace. The fund pays compensation to permanent and casual workers, trainees, and apprentices who are injured or contract a disease. So it's important that all of those people are on the payroll. If those people are not on the payroll and you can't prove that they're on the payroll and be included in your return of earnings, you're going to have a problem, and you may be exposed to some sort of civil litigation. You're eligible to claim if you're permanently employed, a domestic worker in a boarding house, or employed in a business setup, an apprentice or trainee, a worker paid by a labour agency. You cannot claim if you are a member of the SANDF, SAPS, a worker who doesn't work under the control of an employer, for example, a subcontractor. Now that subcontractor would be required to be registered separately. And I urge you, if you've got people on site doing work for you, that you get that letter of good standing as proof that they're registered and they're in good standing, because you don't want a situation where you become liable for claims of subcontractors. And a worker who works outside South Africa for more than 12 months has to enter into an agreement with the Department of Labour to be included in workman's comp, otherwise they're excluded. Or if you're found guilty of willful misconduct, unless you're seriously disabled or killed. So if you've done something to deliberately make a claim because you're just tired of working, you would have a problem. Compensation benefits will not be paid if you report the accident to the employer more than 12 months after the accident or death, or after the disease was diagnosed. Obviously, 12 months is there to make sure that this incident actually happened in that period on site or in the course of your duties. Also, it will not be paid if you're off for 3 days or less, as we discussed previously, or the accident resulted on your own negligence or wrongdoing, or you reasonably refuse or willfully neglect to have medical treatment. Obviously, if you're not going to have medical treatment if something happens to you, then you're on your own. The next slide was included in this presentation for COVID cases, and I urge you to read that in your own time. It's actually 3 slides. And the crux of the matter is, during COVID, people were sent home, and your employer can't be held responsible for injuries at your place of residence because they do not have access to managing and monitoring challenges such as things that could cause you harm. But the article is written by a labor practitioner, and I urge you to read it because, you know, coming out of COVID is more people working from home. And the article starts with, you're not covered, to you may be covered, to you are covered. So read it through. It's quite an interesting article. And I think the crux of the matter is, if your employer is requiring you to work from home, they have a responsibility and due care to ensure that you are working in a safe space. So, you know, I'm not talking short-term working from home. I'm talking to you not provided with a space by your employer, and you are required to work home as a condition of employment. So I urge you to read that. It's quite an interesting article. And as an employer, it would be a good idea to cover yourself. Now, the COID reporting and claims process is a process that HR Talk can assist you with. So if you need our help, let me know and I'll put you in touch with Teresa. So the process is, the employee must report the injury to their direct line manager, supervisor. The employer must report the accident or disease to the Compensation Commissioner within 7 days of an injury, or 14 days after knowing of a disease. Now, I think that may be extended in the case where it's taken time for a diagnosis. Workers must get the WCL2 or WCL1 form from the employer and take it with them to the doctor. The form must be completed by the doctor and must be handed back to the employer. The doctor must send a first medical report, which is a WCL4 form, detailing the disease and injury and the likely period that the employee will be off work. The employer must send the first medical report to the commissioner. The employer must keep copies of the employer's report, records and evidence, and witness statements, and all notices must be sent to the commissioners, because that's going to form the basis of various decisions. The doctor must also send progress medical reports monthly while treatment is progressing. The doctor must send a final medical report stating that the employee is fit to return to work or that the employee is permanently disabled. Obviously, that letter will then go to the committee and a decision will be made as to whether the employee will get disability benefits. The employer will send this medical report to the commissioner. The employer sends a resumption report to the commissioner when the employee starts back at their workplace. And the employer also fills in this form to claim back the compensation during the first 3 months of any claim. Remember, the first 3 months, the employer is required to pay the salary, and this form will enable them to get a refund of those 3 months' salary. Once the commissioner's office has all the forms, they've done all their meetings and they're happy, they will make payments, but this process can take months to come through. If you have an injury on duty, there's a process that needs to be followed, and that is the duly completed employee's report of an accident, a valid certified ID of this person, a driver's license, passport, birth certificate, work permit, etc. relevant questionnaires relating to the specific incident, if and where obviously applicable. So a transport questionnaire, an assault questionnaire, those would all have to form part of your submission. Then your first medical reports, or a valid medical report with a full clinical description by a medical practitioner, as we've discussed. For claims relating to post-traumatic stress, a first medical report by a psychiatrist, which is called a WCL 303, that would be required. And then any other reports that would have any influence on the ability to claim. In the case of a needle prick or exposure to blood injuries, in the case of health workers or occupational nurses, pathologist reports would be needed. A duly completed employer report on an occupational disease form would have to be submitted. Valid documentation relating to home affairs for foreigners, IDs, notice of the accident must be completed, relevant questionnaires, first medical reports, and histology biopsy reports. Pretty much the same types of process that you have to follow. In terms of additional documentation, radiologist reports confirming a diagnosis, chest x-ray reports, lung function tests, lab reports, lab investigations. If this relates to a noise issue, a hearing issue, there would have to be obviously reports from an audiologist, diagnostic audiograms, and a report from the ear, nose, and throat specialist. A full medical report detailing symptoms and signs and a specific diagnosis with the reports, special investigations, together with any special detail of treatment, administration, or plan also has to be submitted. Now, in terms of doing an online registration of this report, you're required to do it via the compeasylabor.gov.za link, and this system can be accessed by anyone who's registered as a user. So I urge you to do that process. As I said, we can assist you with that. The reason I said I would suggest using professional is because of the delays in time. You know, you make a mistake, it takes a long time for them to send back the request for additional information, and you're dragging out the process and potentially putting the employee at risk. What documents will we need from you? We would need CRPC documents for your company, proof of the business resident or the residential address of the business, proof of director residence, proof of residence of any designated person who's representing the company, the ID of the director, completed user nomination form, and the ID of the user. As I said to you, this is all a very slow process, but it's imperative that you don't hamstring yourself or the employee by missing deadlines. Get the process started, make sure that you're thorough in terms of what you submit, and that will speed up the process significantly. Okay, we've come to the end of the actual presentation. I just want to have a look at questions. Okay, in terms of how COID applies to offshore contractors and their direct employees, as I said, if they're going to be out of South Africa for more than 12 months, you have to consult and get a directive from the Compensation Commissioner. If I was you, Michelle, I would also get private cover. I know that if you're on medical aid, also if you notify your medical aid, they will provide you with a letter, and that provides cover. My dad travels quite a lot to visit, obviously, family overseas, and I always get the letter for him to prove that he is covered by medical aid so that he can go to a facility in another country and receive treatment. Now, I would say the same. In terms of occupational injuries and diseases, I would make full disclosure to the Compensation Commissioner of your South African employees who are going to be off-site or are going to be, out of South Africa for more than 12 months and get direction from them. You do not want a situation where there is a case of malaria or someone is killed and there's no claim allowed. Fixed-term employees covered by COID, definitely. I'm of the opinion that anyone who's working on your site should be put on the payroll system and covered by COID. You know, we even talk about, you know, mothers at schools who do traffic duty. You know, we've had cases where people have been injured in the parking lots of a school directing traffic. You know, put that person on the payroll so that we can at least show that they covered by COID. You can put them, you know, in at a nominal remuneration of R1 or whatever, but you do not want a situation where the person is put in a crisis financial situation in that they're injured and they can't get the due care. Same with learners. Same with part-time employees. Those people are exposed to the same risks that anyone else is. Laura, why is changing a business category such a huge issue? Because the workman's compensation think that we all are dishonest. I use, as I said, a third-party person in Johannesburg. And the reason I use that person is because I get better results in cases like this. Let's just take a scenario, and it's something I should have maybe mentioned earlier. Your company is called ABC Transport and Logistics, okay? And you, in error on your application, say we work in the transport and logistics field. You're going to get put in a category that deals with trucking, warehousing, transport, and logistics. In my client's case, they all work in a control room with aircon, with modern laptops, internet access, and they do an administration task. All they do is they shuffle around instructions for trucking, warehousing companies. It would be wrong for that company to be put in a logistics risk category because they're going to now pay a much higher COID fee. So it's important when you do the registration that you actually say, whilst we work in transport and logistics, all our employees work in an administrative capacity in an office and have limited risk exposure. My guy Willem makes sure that they get this completely right. Because as I said in the beginning, you can put in, you know, whatever your company does. We work on the recalibration of X-ray equipment. They're going to put you in a category that most likely fits what they think you do. And the person doing the registration might have no clue what a X-ray equipment is, you know. So you might get put in the wrong category. And so I'm sure that Willem puts me in the right category for our clients. And then when it comes to changing categories, business does change. So inevitably, they would ask you for an affidavit. So they want you to go to a police station specifically and make an affidavit to say what has changed and why you want your risk category changed. The other challenge that employers have is you might have two very, very different classes of employees. So you might have a huge administration section, and you might have a smaller factory section. You would be shooting yourself in the foot by putting in that you work in administration, because when you have a factory injury or death, you're going to have a problem. So you would have to make dual disclosure, and generally what the Compensation Commissioner will then request is a list of employees, names, ID numbers, salaries, job tasks, and in which category they're going to fall, and then they would make some sort of decision as to what your status is. So very, very messy. Takes a hell of a long time, and an organization I don't like dealing with. Shane says, when does the WG29 objection against the decision come into play? Challenging one, Shane. What I will do is, if you can drop me an email, and if any of you got any other questions, you're welcome to drop me an email at Dave, D-A-V-E, at hrtalk, HRTORQUE.co.za. Shane, drop me an email. I will get Harusha to come back to you on this, because this is her area of expertise. I don't work on the coalface in terms of the lodging of claims. So let me chat to her, and if necessary, I'll chat to Willem in terms of what his experience is in terms of what's allowable and what's not allowable in the space. Okay, Laura, same. If you can just drop me an email, I will give you I'll give you their details. I will also get Candice to send you all the slides immediately after this presentation. Okay, Michelle, going back to Michelle's query relating to contractors that will be coming into South Africa for a project for a limited duration. Challenging question, Michelle, because if they're not on your payroll, I can't see how they're going to, be able to claim. It would depend who is bringing them in. I would get some sort of declaration by the person bringing them in as to whether they covered for injury or accident on duty. There is a possibility that they could claim through you, but due to the cost of incidents, I would rather go the first route that I suggested. Get them to make some sort of a declaration that these people are covered for injuries and accidents at the workplace. Joseph, commission is included. Challenging because it's not really regular earnings, but it would be unfair to exclude a commissioned agent from making a claim. Michelle, going back to your query regarding the fact that these people are registered in other countries and maybe not have a COID equivalent, I would suggest that they look to get personal accident cover for the period that they're in South Africa in that case. Laura, in terms of the options to choose from online, that's the reason why I don't do it online. It does my head in. I know that Workman's Comp wanted to limit the categories, but what they do is, I think it's a money-making racket, because it's lumping too many different types of entities into the same category. So when I use Willem from Circ, I generally make sure that he's fully aware of what the company does and that we're going into the best possible category for that company. Let's see. Joseph answered that. Okay, so workman's compensation. Joseph, you're right. UIF, if the person works for you for more than 24 hours a month, they have to register for UIF purposes. There's no such requirement for COID. We have obviously posed that question because registering for COID is onerous and there's obviously a high cost for it. So unfortunately at the moment, you are required to be registered irrespective. Christina, we have the same problem, in terms of the length of time, in terms of claims. There's absolutely nothing you can do. This is, in terms of the organizations that I deal with, this organization is the PITS. I am a member of the Payroll Authors Group, or HR Talkers, so I deal with the Payroll Authors Group a lot. The words coming from them are that COID is improving and they care. The only thing I've seen with COID is there's more auditors out, and I know they've appointed external auditors as well. So, look, I think any government organization is loath to pay out money, and they're terrible. Followed closely by UIF. Edward, I will speak to you offline. You're talking about revisiting the transfer from COID to, how would the process look? In your organization, I'm pretty sure you have to be a member of COID, not FEM. Kolani, the question is definition of injury and illness. It must be caused by work. Will an employee who works as an administrator qualify for a claim of spilled water or slipping on the floor? My answer would be yes. We've actually had some claims of slipping. The point is there was an injury while you were your duty. The fact that you were making your coffee, I think would fall into your definition of duties. Christy says that if our business leases rooms, offices to outside companies, would we need to get their letter of good standing? You're leasing, I assume you're leasing office space and they're bringing their own employees in. Look, I mean, it wouldn't hurt, because once you've got the letter of good standing, you know that if anything happens on site, they're responsible for their own employees. I think they would be responsible for their own employees anyway, irrespective of whether they own or they rent the premises. But look, I mean, we ask for the letter of good standing for every single person who comes on site. Whether it be one of our independent contractors, people who do HR work for us or not, because we do not want to get pulled into a 10-year legal dispute. Shane, FEM, are they overseeing entity for COID? FEM is exactly like COID and RMA. They're a private entity that is licensed by COID to provide the same services. So you'll often go to a construction company and ask them, are they registered for COID? And they say, no, they deal with FEM. Between me and you, FEM and RMA provide significantly better service. They provide road shows and seminars all the time. So if you are in the qualifying categories, it would probably be better to be with them. Dealing with COID is a problem. Dealing with UIF in terms of linking PAYE numbers to UIF numbers, it's just an absolute disaster. And the people that we deal with at these organizations who are efficient, unfortunately, we hammer them to death with queries. And sooner or later, they go missing because they're sick and tired of us. Communicating with a generic email address where every single time you ask a query or a query on a related query, you're getting different answers. It's just not good enough. And as I said, we're having huge problems with the electronic UIF certificate of compliance system. So we're hoping that's going to be up and running by the third quarter of this year, but that's no promise. Okay, folks, that's it. If there's any other issues, drop me an email at dave@hrtorque.co.za, and I'll try and find the answer for you. And just a reminder, on the 29th of March, I'm going to be doing the Employees Tax Year-End webinar. Not too many issues this year. We're going to repeat a couple of issues because people are naughty and have not fixing certain things. But I'm hoping that one should also just be an hour, maybe just over an hour. And yeah, it's important if you work in the payroll space that you attend that. Thank you for your time. Have a lovely day, and we will chat soon.